Good afternoon, everyone. This is the Indiana Civil Rights Commission Fair Housing and Familial Status Discrimination training. So my name is Kylie Kramer. I serve as the Public Outreach and Education Manager here in the External Affairs Department here at the Indiana Civil Rights Commission.
And I'm Tracy Richardson. I am the Director of the Alternative Dispute and Resolution and Compliance Department. I'm a staff attorney with the Indiana Civil Rights Commission as well.
We would like to thank you all for signing up today and attending the Indiana Housing Community and Development Authority IHCDA training. Funded properties required fair housing training today. This training is brought to you by the Indiana Civil Rights Commission in partnership with IHCDA. During today's training, we will call out 2 code words. Please write down those code words because we will, at the end of the training, send out an email that will go out to the email address that you used to register. And this email will contain a link that you will need to use to verify today's attendance. So those 2 will be, the 2 words will be announced throughout this training at random times. We will not be telling them at the end, and we will not be talking about them at the end as well. So we'll announce it once and that will be it. So please do not in the chat ask what the 2 code words are. And if you have any information regarding any of this, please follow up with Stephanie Sloan here at ICRC with any questions. Her telephone number is 317-233-6144. Again, her telephone number is 317-233-6144. And we are going to move on to our itinerary. So we are going to talk today about the ICRC mission, our jurisdiction, litigating with ICRC, fair housing laws, similarities and differences to federal and state law, disparate treatment, disparate impact, harassment, familial status discrimination, and implicit bias. So our enforcement areas here at ICRC, these are the places that we are allowed to have jurisdiction over and allow complaints to come in via housing/real estate, employment, public accommodation/modifications, credit, and education. So our purpose here at the Indiana Civil Rights Commission is to enforce, investigate, and educate. We are not here to create laws. We are here to just enforce the Indiana civil rights law and federal state law. We're here to investigate any complaints that come in, and we're also here to educate, and that's where I come in to educate based on the BO trainings, whether it's all over the state of Indiana or you come to us via our virtual
and just to clarify, we enforce the Indiana civil rights laws under 22.9, and we also enforce the federal, or I apologize, not federal. That's what I wanted to correct. The Indiana State Fair Housing Act under 22.9.5. So that is our enforcement authority, not an advocacy agency, but we actually do have enforcement authority for complaints, investigation, and if required, litigation, and at times mediation over complaints filed with the Fair Housing Act and the Indiana Civil Rights laws, both state laws.
So the importance of fair housing is to create security, stability, and safety. I know Tracy can go more into this on why fair housing is so important to Hoosiers and anyone passing through the state of Indiana.
And we'll just briefly touch on the Indiana Civil Rights Act and the Fair Housing Act. The Fair Housing Act and the code specifically discusses the intention to mirror the federal fair housing rights. When Congress created that act, there were discussions about the importance of equal access to fair housing. A lot of that importance goes back to issues for individuals of security, stability, safety that is provided in fair housing, social and economic mobility. Without access to fair housing, it is very difficult in all of the enforcement areas under the civil rights laws to provide equal opportunity. So it is a very important component of civil rights legislation.
So with going into the importance, we can also see this carry on to this graph. So this is discussing the racial and ethnic diversity that is increasing from the 1990s to 2030, which is very important as we are nearing it more and more. But as we can see, the racial and ethnic diversity is actually increasing dramatically, and it is important that with these increases in these communities, we also increase our understanding and our acknowledgement and our education to create
the
civil
importance
rights.
of equal rights. Yes,
Yes.
it's really important as our population becomes more diverse, that everyone has an opportunity and equal access, whether it's fair housing or other civil rights laws.
So again, this is our jurisdiction and what you hit at a little bit earlier. I don't know if you want to go into these a little bit more or talk about them further, but if not, we can discuss these further. If you do have any questions about anything that we've been talking about so far, our Q&A section is open.
Yeah, just to touch on again, our jurisdiction is the Indiana Civil Rights Law as well as the Indiana Fair Housing Act. Title 910 of the Administrative Code is kind of our administrative guidelines with how we kind of administer our enforcement areas.
So our protected class is under the Indiana Fair Housing Act, in which a person may not be treated differently because of race, religion, color, sex, disability, national origin, and the main reason we're here is familial status. So who is all subject to fair housing laws? And Tracy said it earlier, this is really would like to say everybody, but this includes sellers, landlords, leasing agents, homeowner associations, realtors, mortgage providers, and individuals as well with discriminatory statements and interference.
And also we talk about companies, corporations, everyone, partnerships, everyone is subject to the Fair Housing Act. The definition is literally a person within the Indiana Fair Housing Act. So that could encompass any type of corporation or organization and individuals in specific areas. And we've listed discriminatory statements and interference can actually impose individual liability. So the Fair Housing Act is kind of unique in that area. But unless you are exempt in specific instances, generally not a complete exemption because there's still areas that you could be subject to the Fair Housing Act, but unless you meet an exemption for some of the requirements of the Fair Housing Act, you are covered.
Yeah, and as Tracy alluded to, these are who are not subject to fair housing. So this could be religious organizations, private clubs not open to the public, housing for older persons, Miss Murphy exemption. Organizations cannot have racially discriminatory practices.
Yeah, so and that's what when we talk about having certain exemptions in specific instances, there will be areas that you may not be liable. Housing for older persons, you're not going to be liable for familial status discrimination because you don't allow individuals under 62 or under 55. There's a requirement for an 80% occupancy of 55 and older because those guidelines have been met by those providers. They're not going to be subject to familial status discrimination, but they could still be subject to race discrimination. If there was a complaint filed and it appeared that they were perhaps making a discriminatory statement in advertising, or perhaps in their practices for negotiating for a space or actually renting a space, it seemed to have been discriminatory, then there could be some liability in that area. So the exemptions exempt in certain areas, but there's not a complete exemption from the Federal Fair Housing Act, really for any instances. And again, kind of want to make people aware that the Fair Housing Act is one area where there is the potential for individual liability as well. So very important to understand those laws and guidelines.
So we're going to quickly touch on this, but who can file? So that's how the Indiana Civil Rights Commission starts with a complaint. So it's any aggrieved person can file a complaint. They can be showing that they have been or will be injured by a discriminatory housing practice. This can include fair housing organizations, testers, individuals of any race, or an employee of a housing provider as well.
And so just as a housing provider, it's important that, you know, some people have questions about fair housing organizations or testers, but testing is something that is done frequently by fair housing, particularly advocacy organizations. It is done by the Indiana Civil Rights Commission. The Supreme Court has found that testers, fair housing organizations, do have an interest under fair housing and civil rights laws. So they do have an interest that can be violated. They are appropriate complainants, so they can file complaints. So if a complaint had been filed against your organization based on testing, it's not going to be knocked out because that individual actually was not looking for a property. The courts have found that certain types of discrimination, whether it's a discriminatory statement or a statement of a particular steering type statement of non-availability, is the discriminatory act in and of itself. And when it's based on a protected class, that is protected. And so a complaint can be filed with fair housing organizations when an organization has to go above and beyond their costs for assisting with discrimination that a tester has experienced, or if they are assisting and gone beyond what they normally do. If it's outside of their scope, generally they can file a complaint. If there are additional costs, if there is additional work that has to be done because of discriminatory acts, particularly with respect to their testers, those are complaints that can be filed. So you don't want, as a housing provider, to be of the mind that, well, these individuals weren't looking for homes. This is just an organization. These are just testers. I should not be subject to the act. Liability won't be found, because that simply isn't true. Liability can be found, and it can be the same type of requirements for not only the affirmative relief that is generally required when it comes to a finding of liability, but there can be financial implications. So it's really important to understand it's not just individuals that come to you, that ask, that want to apply for housing, that are filing if you are found to be engaging in some type of discriminatory practice that is under the Fair Housing Act. So it's important to know all of it. So types of discrimination, and this is good to know, and we definitely recommend that you also write these down and not just listen for the 2 code words, but also understand that this is also note taking and this is a training. So this is good to know for future reference as well. So we'll just briefly touch on these and give some examples to each one. The discriminatory statements, steering, blockbusting, failure to accommodate or allow modifications, discriminatory residential real estate transaction, intimidation or interference, or denial. These are all types of discrimination that are absolutely prohibited under our laws that we follow under here. Right. These are very specific to the Indiana Fair Housing Act. Of course, there's the counterpart in the Federal Fair Housing Act as well. Very specific types of discrimination that are prohibited. So any of these acts that are done and they are done based on protected classes, and that link is shown, that's where the discrimination is shown. So we can start with discriminatory statements. A discriminatory statement can be a statement or it can be advertising. And anytime there's a statement made that to a ordinary listener standard, kind of to a potential applicant, gives an indication there is a preference for a specific type of applicant, and that is based, again, on the protected classes that we discuss, whether that's race or religion or sex or familial status. national origin, any of our protected classes, if there's a statement made that gives an indication that your preference is something different other than that protected class, that could be found to be a discriminatory statement. And that includes your advertising. If you have advertising that consistently only presents one type of individual, if there's no diversity in your advertising, if there's an advertising that only appears to include a certain age, and of course, we are not talking about specific 62 and over and 55 and older with an 80% capacity housing with older persons. But if you simply are a housing provider and your advertising seems to appear to only appeal to a specific type of individual under our protected class and does not exhibit the kind of diversity that's indicated in our protected classes, that could be deemed discriminatory. If you make a statement to someone, we don't have a lot of families around here. When someone comes and makes an application and you see they've got 2 or 3 children with them, and it may be that the preference is for a quiet individual that kind of pays their rent and goes about their way. But fair housing is supposed to be open and access is supposed to be equivalent for everyone. Steering kind of along those lines, making a statement, again, based on a protected class, there has to be a showing of a link that this is done based on a protected class. So you make a comment to someone and say, I think you will enjoy living over there a little better. You will feel more comfortable a little better. There are more people like you at that particular facility, or I think your children will probably have more people to play with. Those types of statements can be not only found to be discriminatory statements, that can also be found to be steering. Attempting to influence someone to live in a particular area, particularly if that area is a area with more individuals of that person's protected class. So you want to be careful about comments that are made, and you want to be led by the individual making the application. Allow them to tell you what they want and where they want to be and what is important to them.
And if you want more examples on each of these, and if you want more examples and us to go more in depth on any of these, definitely let us know. The Q&A is open as well. But we want to do more. We want to go further into our familial status. Similarities to our Federal Fair Housing Act are the protected classes, your covered housing providers, exemptions from the act, mission, who can file, theories of discrimination, as well as types of discrimination that is prohibited as well. So we're going to take a quick second here to allow all that information really to absorb. And if you have any questions so far, please feel free to put them in the Q&A. I will say your first word as of right now is steering. The first code word is steering. And we will be back in 5 seconds. All right. And again, if you have any questions or wants to go in further detail, please let us know. So we're going to move on to theories of discrimination. So this includes disparate treatment, impact, and harassment.
And so just to define disparate treatment is literally what it sounds like when individuals are treated differently based on any of the protected classes under our statute. Disparate impact is a little different. You can have a facially neutral policy, but if it has a disparate or negative, when we use the word disparate, different but negative impact on that particular protected class, again, it has to be based on a protected class under our statute. If there's a disparate, different impact, a negative impact, consistently to a certain group of individuals, then your policy could come under question as racially discriminatory or whatever class, familial status, whatever that protected class is. And also, harassment is another area that's important to understand. Harassment is an area of that could be quid pro quo. It could be hostile environment. It's important to understand that harassment can occur from a housing provider. It can occur from a housing provider's employee, and it can also occur and a housing provider can incur liability from an individual that is renting in that provider's space. If you have been, if someone has filed complaints, discussed with you or your property manager that something is going on and it has been shown to rise to the level of what we legally define as coercion, intimidation, or interference in the exercise of an individual's fair housing right, then you could be held liable if you ignore those complaints and you don't investigate and ensure that if it is going on, that it stops. So it's important when you have a complaint that comes in under that capacity of harassment that you kind of ensure that that's not occurring. It's important that your staff or you as a housing provider are not engaging, and that could include sexual harassment, and again, any type of harassment that has to do with our protected classes, that is not occurring. And that also can go to harassment that can be seen as not listening to a tenant's needs as far as repair. If it's a consistent problem that they are being ignored, it could be deemed harassing type behavior because you are ignoring the needs of that tenant that's providing that rental income for you.
Yeah, and to kind of put everything that Tracy said onto a slide that you can see. So this is disparate treatment, but we also want to go into some examples. So strictly regarding to familial status, disparate treatment example could be placing restrictions on a tenant's lease for the use of the pool because the tenant has children or a child. That could be a great example of something that is discrimination.
Particularly when no one else has those restrictions. So if you're going to restrict any tenant that has children to pool use certain hours, certain days of the week, only on the weekend, that type of thing, then you're going to have a potential issue for a familial status discrimination complaint filing.
Yeah. And here we go into disparate impact, which again is about the rule and the policy and practice. So that is something that Tracy pointed out to me. It's this one, disparate impact is more about the rule and the policy, where the other one is the individual.
It's generally, and we kind of want to caveat this one because disparate impact, the policy is generally facially neutral. It doesn't implicate any of our protected classes, but what it will do is it will affect a protected class far more than it would any of the other classes. And so if you see one type of class that is being affected by a facially neutral policy that you've created, you should be careful because that could be seen as disparate impact.
Yeah. And This is going into what you already said about harassment, things that are the forms of harassment under the Indiana Fair Housing Act: sexual harassment, housing provider untended, tenant untended, and then it can even go as far as criminal harassment as well. So you already talked about the quid pro quo and how it's unwelcome, and they've made it clearly unwelcome, whether it be a lewd comment or things of that nature. So this just goes into our sections and then our Indiana code, which it talks about
Yes.
just harassment.
That's our specific
Yeah.
definition under the Fair Housing Act. And again, that's what we discuss: intimidation or interference with the exercise of another's fair housing right. So that is our civil harassment enforcement. And another reason we placed it is just to show the similarity of that with the federal harassment statute. Again, our law was intended to provide the same rights and responsibilities that the Federal Fair Housing Act provides. And the same way there is a civil component for harassment in the federal law, we also have a civil component of harassment under our state law. It is rather broad. It can encompass many things: coercion, intimidation, threatening, interfering with the exercise or enjoyment of their fair housing right. And that would be, again, based on a particular protected class. So there does have to be a showing that it is based on a particular protected class, but we do enforce the same rights that the federal civil laws enforce under our state law.
Mm-hmm. And then it can go as far as criminal.
Yes, and we do have a criminal component as well. So there is a criminal harassment statute under our law. Again, it's the same type of interference, intimidation with the exercise of another fair housing right. Again, it would be based on an individual's protected class status under the Indiana Fair Housing Act, and we kind of discussed that. That does include familial status. This is when they rise to the level of violence. Under our state laws, they can be forwarded, those type of complaints, to a federal prosecutor. So it's really important, again, when we talk about when they start out under the civil laws, when it may be just some harassment, name calling. We understand at times tenants have disagreements. They have issues under a variety of issues, but it's important that those are addressed, particularly when someone says that it has something to do with any specific protected class, whether that's disability, whether that's race, whether it's familial status. And you don't want them to rise to the level of criminality because, again, there is jurisdiction. There's jurisdiction to send these to the prosecutor's office the same way the federal statute has that jurisdiction to send criminal types of harassment to the Department of Justice.
And again, this is just going into the federal law that you were discussing. So we want to talk about determining harassment and how we form jurisdiction over this. And this could be the nature of the conduct, the context in which it occurred, the severity, the scope, the frequency, the duration, location, and the relationship of the persons involved. So we are going to ask for some scenarios, and you are allowed to, again, put your answers in the Q&A and kind of explain why you think this, or if you think one way or the other. Landlord continues to make unwelcome frequent visits to single female tenant's property. Tenant has requested the landlord to email or call if there are any further issues where landlord would need to visit the tenant's property. Landlord continues to make unwelcome visits and dismisses female tenant's request. Again, is a form of sexual harassment. If you think that, why? And we can move on to the next one. So tenant, upon realizing that there is a new immigrant family next door to tenant, consistently files complaints against an immigrant family because of the smell of their food and the volume of their dialect. Tenant has made unkind comments about immigrants. Immigrant family has complained to property manager. Property manager replies, people have right to their own opinion. Is this a form of harassment? again, these are kind of allowing people to understand where they have crossed the line, or even if they are realizing that they have been discriminatory or making, again, your discriminatory statements. So we can talk a little bit more about the differences of federal Fair Housing Act compared to what ICRC has jurisdiction over and things of that nature. So this includes our emotional support animals. Indiana does have emotional support legislation. Indiana has legislation that makes misrepresentation of an ESA or an emotional support animal classification or a Class A infraction. So I don't know if you want to speak more to this.
Yeah, that is kind of what the difference is from the federal legislation. It is not a Class A infraction. There is no criminal statute with respect to the misrepresentation of an emotional support animal. The federal law does not really discuss misrepresentation. I believe Indiana is only one of 7 states that has legislation that makes misrepresentation of an ESA an infraction. And because of that, our complaints regarding emotional support animals are sent to HUD. It is found actually not in the Civil Rights Act. I'm sorry, not in the Fair Housing Act, but actually in the Civil Rights Law. However, there are many implications in the Fair Housing Act regarding what we call support animals, which could include emotional support animals and the right to an emotional support animal or to a service animal, which is distinct from an emotional support animal. And we kind of put that all together with support animal legislation and discussion. But that is one of our differences from the federal acts.
Mm-hmm. And we talk about this in other places as well. So if you are interested in learning more about emotional support animals and things of that nature, that's again in a different training. But now we do want to talk about familial status discrimination. And before we dive into that, if there are any questions before we move forward with this information, please again put them in the Q&A. We will be answering those questions later on. So ICRC familial status discrimination definition under the Indiana Fair Housing Act. Under this article, a discriminatory act is committed because of familial status if the act is committed because the person who is subject of discrimination is 1, pregnant, domiciled with an individual younger than 18 years of age, in regard to whom the person is the parent or legal custodian, or has the written permission of the parent or legal custodian for domicile with that person, or 3, in the process of obtaining legal custody of an individual younger than 18 years of age. Is there anything you'd like to add on this?
Yeah, no, it's pretty self-explanatory. So you can either be pregnant, and some people don't understand that if there are issues that occur, potential discriminatory statements or actions or behavior that seems to point to the fact that someone is expecting and that appears to be an issue, or they have children, or if they are in the process of obtaining custody of children. When I think of pregnancy, I think of implications that we've had recently within our agency of housing providers that like to call themselves student housing, but they are not connected to that particular university as actual dormitory housing. And they have filed complaints because once an individual that is in that, what they like to advertise, which in and of itself is a discriminatory statement, that they are student housing when in fact they're not. When an individual becomes pregnant, for some reason, we've had complainants who have not been able to renew leases. And some of those providers, their preference, obviously, in some of those college towns is for students. But if you are not, they're not actual student housing. So there is no right based on pregnancy to not allow an individual to renew a lease. So when it comes to pregnancy, that's an example that comes to mind.
Yeah, and that's a wonderful example. And so just broadening on that, it can be played out in occupancy standards that are unreasonable, like you said, with pregnancy and things of that nature. HUD's Keating memo provides the occupancy policies of 2 persons per bedroom as a general rule is reasonable under the Fair Housing Act. I don't know if you'd like to add anything to that.
Well, just to discuss as we're moving into occupancy standards, because occupancy standards can be implicated and are often implicated in familial housing discrimination. And the reason for that is we often find a lot of housing providers that want to tell certain size families based on the number of children, how many rooms they are required to rent. And you really have to be careful about doing that, because you can be found to be engaging in some familial status discrimination, especially if your occupancy standards are found not to be reasonable. There is a Keating memo. Again, as we discussed, we do follow federal guidance, and we attempt to provide the same rights and responsibilities as the Federal Fair Housing Act. And so some of that guidance kind of discusses occupancy standards and states generally a policy of 2 persons per bedroom as a general rule can be reasonable under the Fair Housing Act. Of course, you could have larger bedrooms, you could have smaller bedrooms that are indicated. At times, plumbing issues can be indicated, as well as the size of the unit that's being made available as a whole. If you have a particular unit, or you're renting a house and it's rather large, there's a lot of square footage, then there could be some considerations made for that, a larger number of bathrooms, that type of thing that says, well, maybe it is reasonable, it's okay to have a larger number, and it may be found to be unreasonable to have an occupancy restriction that is too strict, that doesn't have any flexibility and doesn't look at those other issues. You could be looking at a familial status discrimination complaint.
Advice to avoid discriminatory occupancy standards. So kind of what you were just talking about, avoid limiting number of children per unit, avoid adopting discriminatory rules governing the use of common facilities by individuals under the age of 18. So kind of what we discussed earlier, where children can't be at the pool at this hour, or children just can't be at the pool at all, things of that nature.
And also just to say, even some housing providers, apartment complexes, that type of thing, you don't want to have guidelines that only 10% of my units are going to be rented to families, or only 20% of my units are going to be rented to families. You don't want to have those types of guidelines, because again, we're talking about familial status discrimination, and having a child, being pregnant with a child, being about to adopt a child or take custody of any individual under 18 does not limit their right to access fair housing.
So again, we're going to go into real life scenarios. And again, we would like that you put your answer and your explanation in the Q&A, as some of you have been doing, and we greatly appreciate it. A single mother and 2 small children, ages 1 and 3. Housing provider, after receiving application, says there is only 1 unit available at the top level. Housing provider does not rent to families with children under 5 on the top level because they feel it is dangerous.
So are we going to ask, is that discrimination?
Yeah.
But and just to let you know, I guess we'll provide the answer that, because these are real life scenarios, that is definitely discrimination. It may have been done in an attempt to limit liability. It may have been done with the safety in mind of children. There could be a lot of legitimate reasons for that, but again, you are limiting someone's equal access to fair housing. And so those types of decisions have to be left in the hands of the potential tenant. And so you don't want to have those types of policies, even if they appear to be out of concern for potential tenants, and sometimes as well out of potential liability for the provider as well. You want to ensure you're not going against guidelines of equal access on the basis of familial status.
And again, we hit on this one quite a few times throughout this training with reserving the pool, not allowing individuals under the age of 18 to use neighborhood facilities such as pools or clubhouses that adults are permitted to use. Again, this is discriminatory. It's going against all of familial status.
It can be seen as familial status discrimination. Again, you're taking away that equivalent access. You want to think about, if I'm going to make some kind of regulation or guideline based on safety, I need to make sure that statistically it's based on safety, that it's not based on some type of stereotyping, that it's not based on inconvenience. So if you are closing off your pool when it gets dark, or closing off your pool at 6 o'clock, then it should be closed off to all tenants, as opposed to tenants with families or tenants with children at 6 o'clock.
So with all this being said, there is an exemption from familial status discrimination, and Tracy will go into this, but the Housing for Older Persons Act of 1995.
And again, that exception from familial status discrimination, we kind of talked about it. We've got two levels. You've got housing for older persons 55 and older, and that does require under our state law an 80% occupancy rate of individuals over 55. In that obvious exception, familial status discrimination is not going to occur for having those guidelines, as well as the 62 and older. The familial status discrimination does not apply as long as those providers do meet our state guidelines for those properties. And there are a number of guidelines for those properties found in the Fair Housing Act. Then there is no familial status discrimination that is a concern.
So again, we're going to take a second to allow everyone to gather that information and ask more questions. We are receiving a lot of questions, which we will be answering in a few minutes during our Q&A. But your second word is now occupancy standards. Occupancy standards. And we are going to move forward to make sure that we are all within time. So we are going to talk about implicit bias a little bit and touch a little bit on this. So this is the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner. And this could be, this more dives into what is implicit bias. So it's unconscious and it's automatic. They are malleable as you grow and age in time. They do not always align with your explicit beliefs, real world effects on behavior, and they are pervasive as well.
So implicit bias can kind of come into play again with discrimination, and we've discussed all of our protected classes. Race, I think, is our most common, probably the highest number of cases, but disability as well. And often it's because people have implicit biases about particular races, national origins, disabilities. Can be unconscious and automatic. It may not be something you think. You have stereotypes that you believe about those particular types of individuals, but also people have implicit biases about families with children. And that kind of is the reason that familial status is a protected class. There could be implicit biases that they are going to be a little more destructive with respect to a unit. They're going to have more repair requests. There's going to be a lot more noise. There are going to be issues, and those unconscious and automatic biases can kind of affect policies being created or how individuals are treated, even if it's done on an unconscious basis. So it's really important. It's important to understand fair housing laws. It's important to have fair housing training and understanding in this area of familial status, so that unconscious biases or implicit biases don't affect the way you treat an applicant, perhaps with a large number of children, or an applicant with children at all, because the preference is adults, to have an adult in a unit, or student housing. Again, a lot of times we find people prefer student housing in a college town, but they're not connected to the university. So that preference could actually be seen as discriminatory, because if that's housing that someone needs to have available and that fits their needs, if it's close to their location, if it's something they can afford, if it's something that works for their family, they shouldn't have an issue with attempting to rent, because there's some type of bias you have about what you're going to have to deal with when they become a tenant.
So prevention, and this is a really big slide. And again, if you are taking notes, I definitely encourage that you write these down. But it's basically just knowing and following your fair housing laws. So housing providers should know their responsibilities under the Indiana Fair Housing Act, should train their employees on the Indiana Fair Housing Act to prevent such cases from even starting, should comply with all fair housing posting requirements, and should also include policies and tenant lease agreements as well. Anything to add on top of that?
No, I think, and we kind of touched on that again, the best way to prevent having a complaint filed against you as a provider to begin with is, again, knowledge of the act. And if there is an area of the act, such as familial status, where there may be issues, maybe want to look at practices, perhaps want to look at policies, and perhaps want to look at training that's being given to employees to ensure that there's nothing, definitely nothing that's intentionally put in place that would discourage families with children, or individuals with those domiciled under the age of 18 with them. You don't want discriminatory advertising that makes it appear as if it's a place only for adults when you're not meeting those housing for older person guidelines, and you're not that particular type of housing. You really don't want to advertise that you're student housing when you are not connected to a university. You don't want to discourage individuals who may need your housing, and they may have infants, they may have small children, and your housing may work for them, even if it is in a college town for other reasons than university. You want to ensure that individuals are treated the same when they come to your place of business, that children are not treated differently, so that there's nothing that's being said that makes them feel as if it's not a place for them.
And I think that's a great way to segue into our Q&A session. So we do have some questions already. And again, if you have any others, we definitely recommend that you put them in here. So we have our first one. When advertising for an RD property, can you say something along the lines of, to qualify to live here, you must be 62 or older and or disabled of any age, with or without children?
Well, generally, as long as you are following the state law guidelines on 62 and older properties, there's nothing wrong. Again, they have some exemptions from the Fair Housing Act, familial status discrimination exemption. So as long as you're accurately advertising the type of property that you are, and you are that type of property, there should not be issues with actually advertising that you're that specific older person housing provider. And then this one has to do with the Keating memo. Is the Keating memo note 2 heartbeats per sleeping space or per bedroom? HUD notes sleeping space, which is any room with 2 outlets, no water source, and has a window. So a bedroom could be considered a sleeping space, as could a living room or a den. Is that discrimination? I don't want to answer something that I don't know specifically whether that's sleeping space or bedroom. My recollection is that it's bedroom, 2 heartbeats. But again, the Keating memo also discusses, just as you're mentioning, considering other areas such as the size, the square footage of the unit that's being rented, considering the plumbing. So that's, it's not hard and fast that as long as it's 2, you're good. It could still be seen as familial status discrimination if there's a possibility that more than two really could have been reasonably accommodated because of the way the unit was laid out, because of the plumbing that was available, and a number of other things that, you know, made it okay and left really up to the parent how they wanted to situate those sleeping spaces and living spaces for their family. So the Keating memo is not hard and fast to, and you're definitely good, because there can be a complaint filed when that just isn't reasonable, if it doesn't appear reasonable for a specific, under a specific circumstance. So again, it's a guideline. It's not a case. It is a guideline.
It's a great question. That is all of the questions that we have right now, but I want to offer it to you. Do you have anything that you'd like to expand on that you think could use more expansion or in-depth analysis or things of that nature?
No, I think we've pretty much covered pretty well familial status discrimination, kind of talked about the exemptions, what to look out for, talked about advertising. We've talked about statements being made, because those are all the areas that familial status discrimination generally comes into play. The majority of housing providers don't say, we don't rent to children. We have heard housing providers, or at least being alleged to have said, you have too many children. We want to be very careful about statements such as that. You want to be careful about things such as adding extra fees because of children, the same way some housing providers and without knowledge have perhaps applied extra fees to individuals with disabilities that had specific needs, or emotional support animal needs. At times you'll have providers that think it's okay to add a larger deposit up front that may, based on having children, not return an entire deposit at the end, or simply utilize different types of policies for families with children. You want to make sure that is not something that you're doing, that you have consistent policies that are non-discriminatory and they apply to everyone. So if someone comes in, you want to treat them as if they are coming in on their own. Of course, we do know that there are some counties or cities that have occupancy standards, and that those are generally a lot of housing providers kind of take their occupancy standard guidelines from that county or city. And if those are found to be reasonable, then they're going to be reasonable for the provider. There are occasions when a city or a county's occupancy standards have been found to be unreasonable, but you really want to make sure that they're reasonable based on the guidelines of your particular property. So that's, pretty much a little more discussion when it comes to familial status, is some of the pitfalls that someone that may be subject to a familial status discrimination complaint may fall into. So again, looking at advertising, looking at policies, looking at just the way you treat an applicant that comes in, if they have children with them or tell you they have children, kind of looking at statements that are being made, making sure that there's nothing said or done that could appear discriminatory or that can kind of give an indication that child-free or childless unit or place is the preference. That's not something you want to give off, not something that you want to make an indication of to a potential applicant.
And we are very thankful that everyone has come and joined us today. And again, if you have any further questions, I have put my email up there. And also, if you'd like to just visit the Indiana Civil Rights Commission's website as well, or call in, you are more than welcome to do that if we do not answer any of your questions. We answered all of them in the Q&A, but if you're thinking about things throughout the day or things of that nature, please let us know. We would love to answer all of your questions and make sure we are steering you in the right direction.
I do have
Yes.
one caveat that we didn't speak about at the beginning. I do want to just make a reminder that this is not legal advice. We are not here to give legal advice or provide legal advice to any individuals or housing providers. This is strictly and purely for educational purposes. If you have really specific questions, or if you want to get a good understanding of the Indiana Fair Housing Act, as well as our civil rights laws, it is really important that you enlist the services of a licensed attorney and get that understanding. Of course, as Kylie mentioned, through our external affairs, we do provide trainings such as this. We do other trainings, discussions, things of that nature to help individuals have an understanding. But again, we are not providing actual legal advice to any housing provider at this point. So it's just important that we make that disclaimer.
And then also in about 5 minutes, you will be receiving an email from the Indiana Civil Rights Commission in which you will get that link that you put those 2 words that we've given and provided you today, those 2 code words. You'll put them in that link and it'll direct you on what you need to do and all the information so you do receive your certificate of completion for this training. So be sure to check that that email that you did register for this course for. So make sure to check. If you registered under a big group, make sure to check out that email. So thank you again so much. Thank you, Tracy. Thank you all for participating today and being active in the Q&A. And we hope you have a wonderful rest of your day.